Wait, please, Lord. My lord, I want to beg your permission from listing a my lord mention matter 2 day itself, my lord.
What matter?
Matter pertains to my lord promotion, my lord. My case was not considered. And it has
Today
been
itself.
today
Today is the last day for this court.
small matter, my lord.
Maybe. Small matter also has to be written. Court has to pass the order.
That's true, my lord.
You will complete your argument and move. Then court will have to write.
Small matter, my case was not considered, my lord.
We will give you a date, not today. Not possible.
If possible, my lord. If possible, my lord.
It's not possible. That's why I'm telling you.
Then, my lord, I have no option, my lord.
You want a date? I'll give you a date. You make a mention for a date.
Next week, my lord.
Who's there for the other side?
My lord, central
Government?
Yes.
Government. You want which date?
Can it be, my lord, 6th of February?
6th.
I'm sorry.
Again, Friday.
Make it, my lord, kindly 13th of February.
Friday again.
Friday. Or, my lord, 11th of February, my lord. Then.
Put the date. Give the mention.
How like that?
Oh, this item 4.
Yes.
Your Lordship, this is this is an application for condonation of 31 days delay. Lordship, being aggrieved with the impugn order dated 12/8/2025, the applicants herein have filed a connected regular first appeal.
31 days.
Yeah, 31 days.
Okay, notice is complete.
No, Lordship, this is the first time it's been listed.
No, I don't think so.
Yes, a second time, Lordship. I was
It
on
was
leave.
adjourned last time.
Yes, Lordship.
Heard Ms. H. Nirmal Swami, learned counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of 31 days delay in filing the connected appeal against the heirship certificate number 63 of 2025 and the order passed on 12/8/2025 by the learned civil judge, Senior Division 1, Champhai. Next para, issue notice, returnable by 3 weeks. Applicant to take steps for service of notice upon the respondent. Sole respondent.
Sole respondent.
Okay, then you write applicants, huh? There are 3 of them. Applicants. On the sole respondent by speed post within 3 days. List again after 3 weeks.
Deeply obliged.
I think I'll give you a date. List again after 3, list again on, today is what?
Today is 30th.
List again on 23rd of February.
Item 5.
Yes, my lord, may it please your lordship, the paper book has already been supplied and is yet to be admitted, my lord. And I humbly request that this matter may come up as a fixed item for hearing on 10 February, my lord, if permitted.
What is the urgency? What is the matter regarding?
This appeal challenges the judgment and order dated 13/7/2024
NDNPS,
and the MPS case, my lord.
10 years.
10 years and fine of 10,000 each.
Conviction sentence was passed on which date?
On 7/8/2024, my lord.
He'll come as per his own turn. There are other matters also waiting in line. Now, who's for the respondents? State only.
Yes, Your Lordship. Only the
Have
state.
you received the paper book?
Yes, Your Lordship. We have received.
Please write, parties are represented by the respective councils. And they submit that they have received the paper book. In view of above, registry to list the matter for hearing as per its own turn. Appeal is already admitted. You said it's
Already
yet to be
admitted.
admitted, already admitted.
Okay. Yes. Yes.
Yes.
Oblige.
Item 6.
Yes.
My lord, this is bail application. And we have come with two main grounds only.
Before you proceed, this is the first time before the High Court,
Yes, my lord.
first bail application.
Yes, first bail application.
Can this court take up the matter? Ms. Vanessiami? Because in the last court date, on 16/1, there's a mention in the order that it is also noticed that the order dated 12/12/25 was passed by a different bench, and an attempt may be made for placing the matter before the same bench,
Yes, Your Lordship.
either physically or through VC.
Yes.
Exactly. That is the order.
So,
I believe that it has to be listed on the same bench.
which bench?
But I'm not sure. To me. Zero.
Lordship, Justice Sanjeev.
Right. So why is it to be listed before that same bench? Any particular reason?
I'm not sure, but if I'm not mistaken, Your Lordship, at the first time it was listed, just bail application, it was
Yes.
before that, the Justice
bench.
Sanjeev. So
Right.
because of that reason, I believe,
But that is not what the notification says, isn't it?
yes,
If it's disposed,
yes,
rejected or allowed,
exactly, Your Lordship.
then subsequent cases arising out of the same FIR or whatever, or filed by the same party has to be before the same judge. But here, there's no decision as such.
Yes.
So can there be any bar?
Ideal.
Okay.
Yes, my lord.
So I believe it is not barred, Your Lordship, to be heard today.
But my lord, we can dispose of today because it has pending.
Of course.
Yes.
I'm not on that, whether it can be disposed of today or not. I'm saying whether it can be taken up by this court or not. That's all. And if it can be taken up by any bench, why didn't you all inform the court that time? All of you just stood and heard the order, that's all. You could have said that it can be taken up by anybody. Because there's no other previous bail application before the High Court,
Yes,
which has been allowed or rejected like that. And the first court who issued notice had only issued notice, that's all. So I don't think there's any bar. Correct?
Yes, my lord.
There's no bar, right?
Yes,
So we'll take up the matter. Then, okay, is there a TCR available? TCR is there? Okay. Now you tell me, what is the grounds? You said you have two grounds of bail. What is
Yes,
that?
my lord, we have come with two grounds only, two main grounds. One is already declined by the previous order. That is, we have come with that the petitioner was not informed about the ground of arrest, but this court, this honorable court, vide the order 12/12/2025.
Huh?
This honorable court in the order 12/12/2025, it states that if I may read, my lord, the order, the previous order.
Yes, please read it. I have read it. You also read it. Yes, read.
However, on perusal of the arrest memo, it appears that the ground of arrest have been communicated to the petitioner. That is one of our main ground, but it seems that it is already declined, rejected. But the other ground we have projected is that the accused was not informed about the right to consult the lawyer.
Have you checked the TCR?
Yes, my lord.
What have you seen in the TCR?
Nothing is written there. my
Nothing
lord.
is written there.
Yes,
Are you
about
sure?
You- If I may take Your Lordship on Annex 7, that is page 26. Yes. That is the grounds of arrest. But nothing has mentioned in this ground of arrest that
That you can engage a lawyer.
oh yes, my lord. The accused about the right to consult the lawyer.
How old is the accused person?
Oh. 45 years.
So a person of 45 years, do you think that he'll not know that he cannot engage a lawyer? He can engage a lawyer. Are you to be informed that you can eat food also? You can drink water also. You can rest also if you want.
But
Required?
yes, but my lord,
I don't think so.
I want to.
He was arrested. He knows why he has been arrested. Despite this format has been prepared.
Yes.
Grounds of arrest and right to bail has been explained to you in the language known to you. And as a token of your understanding and acceptance, you have given your signature below, acknowledged. And on the right-hand side is the arresting officer. What more do you require?
But my lord, it doesn't say about the right to consult the lawyer, right to bail only.
Right to bail, whatever it may be, but I don't think that has to be specifically stated. Show me the law which says that you have to, by hook or by crook, you have to inform that you can engage a lawyer if you want to. And if you don't have the means, you can engage a lawyer at the cost of the state. Is there any such decision?
But my lord, in my opinion, there should be a clear information in writing regarding the right to be informed about the right to consult and to be defended by the legal practitioner. So,
Then on what basis did you engage a lawyer in the trial court? If you did not know, you should not have engaged. Even today also, you should not have engaged. Nobody told me that I can engage a lawyer, so I'm in jail. But you have engaged. One in the trial court and one in the high court. You know you can engage. That goes to show, your action goes to show that you are aware of this fact. Any other grounds?
my lord, no other grounds. But
Then we dispose of this.
But my lord, if I may submit one of your lordship judgment here.
Yes, what does it
is-
say? What does it say?
It says about the arrested person shall be informed that he has the right to consult and to be defended by the legal practitioner of his choice. It is clearly written here.
And that is in terms of which judgment?
No, my lord, here, your lordship has made certain guideline here.
Grounds of arrest and right to bail has been explained to you in the language known to you. So bail, how you'll get bail? Just like that. They'll let you walk away like that. Somebody has to file an application, isn't it? Yes. You are aware about this fact. Just because that line is not written here, you're taking that plea. Mr. Ramne Moya, what is the stage of the trial now?
It is in the evidence stage.
Evidence stage. How many witnesses?
There are as many as 4. Not 10 witness.
10.
Yes.
How many examined so far?
4. already examined for,
6 left.
yes.
What about you? Are you going to have any defense witness?
It's up to the evidence given by the prosecution.
Okay. So we'll dispose of part Mr. J. Ram Nemoya, learned counsel for the petitioner, and Ms. Vanessiami, learned additional public prosecutor for the state. Stop. This is an application under section 483 of the BNSS, read with section 37 of the NDNPS Act 1985 for release of the petitioner on bail in connection with NDNPS case number 79 of 2025. Corresponding to E and N case number N-49/2025 under section 21 bracket C oblique 22 bracket C of the NDNPS Act. Stop. It is submitted to the bar that charge sheet has already been submitted in the case. Write charge sheet number EX bracket ANS 47/2025. Under section 21 bracket C and 22 bracket C of the NDNPS Act. Stop. After framing of the charge under the aforesaid section, trial has begun, and out of the 10 prosecution witnesses, 4 prosecution witnesses have been examined so far. Stop. Next para. Mr. Ram Nemoya, learned counsel for the petitioner, submits that the petitioner has been filed for seeking bail on 2 main grounds. Stop. The first ground is that the grounds of arrest has not been communicated to the petitioner. And the second ground is that he has not been informed that he can engage a counsel to defend him and for seeking bail. Now, the learned counsel submits that insofar as the first ground is concerned, an observation has already been made by this court in its order dated 12/12/2025, wherein it was recorded that in the grounds of arrest has been communicated to the petitioner, which can be seen from Annexure 7 of the bail application. Stop. On perusal of Annexure 7, it is seen that the petitioner has been duly explained about the grounds of his arrest and his right to bail in the language known to him. And as a token of acceptance, the petitioner has also subscribed his signature on the body of the grounds of arrest memo. Stop. Insofar as the stand taken by the learned counsel for the petitioner that he has not been informed that he can engage a counsel of his choice to defend him in the trial and for seeking bail as well. It is seen from the memo of the grounds of arrest that apart from the grounds of arrest, the petitioner has been informed his right to bail, and which was explained to him in the language he understood. Although it was not specifically mentioned that he can engage a lawyer of his choice, but the fact remains that the petitioner had engaged a lawyer to apply bail on his behalf before the trial court. Stop. The same was registered as bail application number 438 of 2025. And the bail application was rejected, invite order dated 21/11/2025. Stop. Therefore, the same only goes to show that the petitioner is very much aware about his right to engage a lawyer. And it can be very well understood from the manner in which the explanation has been made to him in the memo of grounds of arrest that he very well might have been informed about the same, and hence the bail application before the trial court. Stop. Even after the said bail application was rejected, the instant bail application has been filed before this court. Stop. Therefore, this court, upon due consideration, is not inclined to entertain the two grounds. And particularly, what was recovered?
10.7 kg of cough syrup. And
22C is what? Commercial quantity.
yes, commercial quantity.
And particularly when the recovered substance is of commercial quantity, prescribing stringent punishment for the same. Stop. Further, the trial is in motion. And under the facts and circumstances, the bail application stands rejected
Yes.
and disposed.
Highly obliged.
Item 7.
One more line. In terms of the order of this court, the TCR was requisition and the same has been sent and duly perused by this court. Yes. Next.
My lord, this is also bail application.
Can it be taken
The
up by this
estate-
court?
Yes, my lord, it's the first time that we're filing before the High Court.
First time in the High Court.
Yeah,
Earlier, you had
just-
withdrawn the bail application.
Yes, my lord.
The same person, same section.
Yes, in person.
You had withdrawn it. indeed.
Yes, my
Okay.
lord.
It was not disposed of on merits anyway, isn't it?
Yes, my lord, it was disposed by the judge.
Who's judge?
So, Justice Goswami.
Goswami. So should it not be placed before him then? This is a second bail application.
No, my lord, this is not the same. This is not.
These are different.
Yes, this is a different case.
Then how do you say that the first, why did you say that the first bail application was disposed of by somebody else?
There are two cases, my lord.
Different cases.
Yeah, different case. That was 21C and this is 21B.
Okay. So two cases are registered.
Yeah, two cases are registered. Yes, my lord.
What? Give me the case numbers. This is 21C.
21B.
Okay, 21B.
This is a seizure of 32 grams of suspected heroin.
32 grams.
Yes, my lord. Which is not seized from her possession.
21B. Now, what is the case number and all that for this?
Uh,
You said two different cases have been registered.
NDNPS case number 27 of 2025 arising out of excise case number 162 of 2025 LLI under section 21B of the NDNPS Act.
LLI.
Lunglei.
Okay.
LLI, yes.
I will be what? Okay. $27.
No, my lord, 32 grams.
No, the case number?
Yes, my lord, the case number is 27.
27. 27 what? What is the nomenclature?
NDNPS case number 27 of 2025.
NDNPS.
Yes, my lord. Arising out of excise case number
162 of 2025, LLI.
167, my lord.
167.
Yes, my lord.
Okay.
of 2025.
And the other one, which was disposed of? Previous one is 21C.
21C,
What is the case number, reference?
SC number 38 of 2024.
Just that, SC only. What was recovered?
My lord, in this case or the one which is already disposed?
Disposed one,
Heroin.
601.14 grams
Yes, my lord.
of heroin.
Yes, my lord.
Bail was rejected.
Bill was allowed, my lord.
Bail was allowed.
Yes, my lord.
21C.
Yes. My lord, it was not recovered from her. She doesn't have any connection in that regard. It was recovered from a driver, a sumo driver. And then from the statement of that driver, she was subsequently arrested. There were so many procedural lapses as well.
Okay, now earlier bail application was 48.
Yes, my lord. SC for
Bail application number 48
Yes, my
of
lord.
2025.
yes, my lord.
And the case number is SC 38.
Yes, my lord. Arising out of SC number 38 of 2024. This 21C was first laid before your lordship, and then, however, your lordship,
It was withdrawn.
yes, it was withdrawn because there was no rejection order. And as
Then
your
you
lordship,
refiled.
yes, as your lordship suggested, we approached the district court at Lunglei, the trial court,
Yes.
and then it was rejected. And thereafter, we again filed another bail application.
Before this court, which is bail application 48 of 25.
Yes, my lord.
And the
And
same
it-
was allowed.
Yes, it was already.
And on what ground was it allowed?
My lord, 22, Article 22 of the Constitution.
Paragraph 15 of the order. Grounds of arrest were not informed to the accused person at the time
Yes,
of arrest. Hence, the arrest is totally illegal. This being the facts, rigors of 37 is not applicable in the present case. So this was the ground.
Yes, my lord.
So you're pressing the same ground in this bail application also.
Yes, my lord.
Although you have been released on bail on that case, but you are still arrested and in custody because of this second case.
Yes, my lord.
Correct?
Yes, my lord.
And why is it listed today?
My lord, it's the first time if notice may be issued.
First time.
Yes, my lord.
Ms. Linda?
Yes, my lord. Seems to be the first time.
Okay. So you'll have to look into that aspect.
Yes, my lord. I'll have to check it.
The other bail application was in fact on that 21C,
That's a commercial.
commercial quantity.
And
This is
while on
21B. And in that case, court said that there was no information, grounds of arrest not informed, so 37 will not apply bail.
Yes.
Now again, she cannot go out because of this second case,
Yes.
which is under 21B. But Ms. Lalngai Sakifanai, learned counsel for the petitioner, who submits that by filing this bail application, the applicant seeks bail. Stop. She submits that the applicant was arrested by the Lunglei police along with a co-accused person for alleged involvement in the seizure of 32.84 grams of suspected heroin. Stop. As a result, NDNPS case number 27 of 2025, corresponding to excise case number 167 of 2025, was registered by the Lunglei police under section 21. Is it small b or capital B? Small b.
Small b.
Small b. 21 bracket small b of the NDNPS Act. Stop. The learned counsel submits that the main grounds for seeking bail, amongst others, is that there has been a gross violation of Article 22 of the Constitution of India, since the grounds of arrest has not been informed to the petitioner. Stop. She further submits that a separate case was also registered against the petitioner involving commercial quantity. That is the case registered is SC number 38 of 2024 under section 21 bracket C of the NDNPS Act for alleged recovery of 601.14 grams of heroin. So the petitioner submitted bail application number 48 of 2025 on the same grounds taken in the present petition, and bail has been granted to the petitioner, provide order dated 1/12/2025. Next para, she therefore submits that the similar direction for release on bail may be passed in the present case as well, since there has been gross violation of Article 22 of the Constitution of India. Next para, issue notice returnable by when?
After a week, my lord.
After a week. We fix a date.
9th of February.
Issue notice returnable by 9th of February 20. 9th of February 2026. Mrs. Linda L. Fumble, learned public prosecutor, accepts notice on behalf of the state, and therefore no formal notice is required. Petitioner to serve copy of the bail application to the learned PP, if not already done. Anything to be called, TCR and all that required? Scan copy,
If it's a ground of arrest, I think TCR may be called, madam.
registry to requisition, scan copy of the TCR from the trial court concerned.
My lord, we had annexed all the charge sheet.
All right, let them also send.
Yes,
We'll
my lord.
compare. We don't disbelieve you. We'll let it be compared.
Yes, my lord.
Please.
Oblige.
Hearing item 8.
This is what? Hearing. Okay. Why don't you call the admission first?
Admission item 1.
Yes, what is this? Admission.
Your Lordship, this is the case where the construction of road, Sherkhan to Baka Road, was constructed.
Mrs. Dinari,
Yes.
let me ask her.
Yes.
Last time you said you wanted to obtain instructions. What is that?
Your Lordship, that was a revised award and it is not required because the main crux of the case in the present case is not relevant. It was just a notification order of the revised award, Your Lordship. Here, Your Lordship, the main bone of contention would be regarding as to whether the 2017, the lessening of the award would be is justified or not, because that was done in
You have
compliance.
filed counter affidavit.
Yes, Your Lordship.
What
that
is
was-
your stand?
Yes, Your Lordship, our stand is that we had complied to the directions of the 167/2017 directions, wherein the court had directed that the faulty the faulty process of verifying has to be rectified, and accordingly, in 2000, between the month of April to May 2018, the re-verification was done by the DC Kolasib with PWD and Land Revenue, and also the coordinate committee, and also the landowners who were
After that, compensation paid,
Yes, Your Lordship. That was in the month of February 2019.
including
It
the
was disturbed.
petitioners?
Yes, Your Lordship. And also, Your Lordship, if I may add that in WA 1 2023, which arose from the challenging of the single judge bench order in WPC 10 2026, Your Lordship had observed in pad number 14 that the challenge of the revision of the compliance to the order of 167/2017 remains redundant, hence infructuous. This was observed by Your Lordship in pad number 14 of the WA 1 2023. Hence, Your Lordship, the revision of the re-verification of the actual land acquired was never questioned, nor was the revision award ever questioned, Your Lordship, by any of the respondents in the WA 2023, and neither in this current 167/2017.
No, after the rectification of whatever error cropped up, some reassessment was made. And
Yes,
that
Your
amount
Lordship.
has been paid to the,
Yes, Your Lordship, that has been
Landowners.
disbursed in February 2019, Your Lordship.
paid to the landowners, including the present rate petitioners.
Yes, Your Lordship. And also, after the re-verification in 2019, 33 new landowners were also included. That is why there is no arbitrary or unfairness conducted on behalf of the state respondents, Your Lordship. That was just a correction.
But there's a difference between the earlier assessment and the subsequent assessment, isn't it?
Yes, Your Lordship, because
That is why they are here.
Yes, Your Lordship, because in the 2014 assessment, the first assessment which was done, it was found that the areas were actually inflated. Hence, after the 167/2017 judgment and order of the single bench, when the actual spot verification, ground spot verification was conducted, they actually only remeasured the actual land which was acquired, which actually was lesser than the inflated one which was previously reported in 2014.
Okay, all those things, has it been demonstrated in your affidavit? That this was the measurement
Your Lordship.
earlier, and after re-verification, the measurement comes into this much, which is less than the original thing, because the original one was inflated by this much.
Yes, Your Lordship.
Have you shown that in
Yes,
your
Your Lordship, in
affidavit?
the additional affidavit which was submitted again in 2021, Your Lordship.
You have submitted in the additional
Your
affidavit?
Lordship.
Okay, we'll come to that. So, the instructions which you sought, you're thinking should be sought, is not required?
No, Your
after all.
Lordship.
All right. Okay, Mrs. Dinari, tell us.
Yes, Your Lordship, firstly, the petition number 167 of 2017, that is in page 32 of my writ petition. The direction of that court is that, kindly see Your Lordship, page 35,
Paragraph?
para 8. From the submission of learned government advocate, it is clear and apparent that the submission of C. Lalram Zaba, the learned senior counsel for the petitioner, has force in as much as the fact of overlapping is to some extent admitted by the state respondents. Keeping in view the statement made in the affidavit in opposition and the grievances of the present petitioners, this writ petition is accordingly disposed of with a direction to the respondent to take into consideration the faulty process which inadvertently crop up in the final compensation list and complete the process both for identification of the actual affected persons and the subsequent disbursal of the compensation to the affected persons within the period of 2 months from the date of receipt of a copy of this order passed today, along with the copy of the writ petition with the annexes annexed to it. The petitions shall take necessary steps to that effect and accordingly submit a copy each of the certified copy of this order along with the copy of the writ petition to the petitioner number 2 and 3. Here, Your Lordship, the direction is to take into consideration the faulty process which inadvertently crop up in the final compensation list and complete the process both for identification of the actual affected persons and subsequently disbursement of compensation to the affected person within a period of 2 months. Here, what they have complied with this judgment is that, Your Lordship, they reassess those who are affected person also. They just reassess. Even though they have visited the place, there is no measurement at all. We are present. And the direction of this court is not to make a reassessment, to see faulty process. And those affected persons should be given within 2 months disburse the award. So the way what they're doing is that if you are bogus claim, it is okay, but you are affected person and we are present at the verification, so there is no complaint at all.
Okay, on the reassessment, your
Yes.
name is there?
Yes,
Original assessment, your name is there?
yes,
And the reassessment, your name is there?
yes.
And in
Just
the
the
reassessment, the amount is less.
less.
What about the area?
The area is same since even though petitioner number 1, Your Lordship, kindly see in my petition, even after the award was passed, verification is there, 2015, it is confirmed that it is genuine.
Where is that?
Kindly see page number 3. Annexure 3, page number 28. You got it, Lordship. Here,
This is the original.
yes, this is the,
This is the first one,
yes,
or the second one?
first assessment, first one. First one is the annexure. Annexure 1 is the first one.
Then what is the next
And
three?
annexure 3 is with regard to the land of the petitioner number 1. Verification, again, they have examined.
Now, how can that be?
Here, Your Lordship, kindly see the,
No, because
Annex.
167 writ petition was disposed of on 19/3/2018.
that is there, where the award, previous award was passed, and they have
No, Ms. Dinar,
question
just-
about the award of the petitioner number 1.
Just show me the first award and the second award.
Yeah,
assessed.
first award is annexure 1, Lordship.
Next one, page.
Page 13, it starts from 13. And the name
13.
13, 1, 3.
Draft award number 3,
Yes.
page 14 in my copy.
Oh, I'm sorry. It starts from, sorry, 14. The name is start from 17, Lordship.
This is the first award.
Yes. Before reassess.
What is the date of the award? 23rd April 2015.
Yes. Award number 3 of 2014.
The date.
The
20
date, yes.
23 for
Yes.
2015. And this is in total of the entire award
Yes, I have marked my name
at,
at serial number 3
yes,
is petitioner number 4.
4.
Yes. And serial number 13, petitioner number 2. And serial number 14, 14 and 14A is the
1.
One.
Petition number 1.
and page number 22, serial number 61, petition number 3.
In total, how many of them?
There are
4. Page
5 of them.
5 of them. You said page
Yeah, yes.
22.
Yes, 2261.
But there is no page 22 in my copy.
Oh, I'm sorry, Your Lordship, I have.
From 21, it jumps to 23. Serial number 61.
61. Petitioner number 3. And serial number 87, page 24.
Digga, you all go and type out. I'll call you out. Now, page?
Page number 24, serial number 87.
Is the petition number 5.
5.
So, in all, there are 5 petitioners.
5 petitions.
How much is the amount computed?
Here, I have a chart in my petition. Your
Where?
Lordship. That is
Page?
in page 7.
7.
Yes.
Previous assessment and reassessment.
Reassessment. Yes.
Now, tell me, what about the area?
Area, here at a previous area,
Huh.
only petitioner number 1 is given the land value. That is in page number 18. Here the area is 1,06,524.
From where do you say that?
Here, page 18, the mark is that
Area of land.
past area of land to be acquired.
And the next one?
The
Value. Value. Next one is the value of the land.
Yes. First is the past, and next is area, and next is the value of the land.
Area is in square feet.
Is area
Square
in
feet.
square feet? Yes, square feet.
What about the others?
The others here, it's not given the land value.
Land value is not given.
Yes, land value is
Then
not.
what is this assessment then?
Assessment is crops.
Crops.
Yeah, others.
4, 2, 6.
Crop is value of crop is before the total amount.
Then all the amounts have been reduced.
Yes, all the amount has been reduced.
Now, in respect of the petitioner number 1,
Yes,
who has whose area of land has been given,
yes.
what is the area of land given in the second assessment?
Second assessment, area of land is given, they have enclosed in their affidavit, Your Lordship.
Page number?
I'll come to them. And there are 3 affidavits, so I have it wrong. The affidavit, additional affidavit filed on 25/8/2021. Page, Annex 1, page 7. That's it, got it? A serial number 16 and 14 petitioners. Here, area is given 6, 13 and 14. Yes. Bigger, much bigger. And with regard to the area, there's a letter. What I said is that in Annexure 3 of my petition, the letter to the Deputy Commissioner here, got it, Lordship, page 28. Page 28 of my petition. 28, Annexure 3. With regard to petitioner, with reference to your letter number, this is with regard to the petitioner's land. Only petitioner's one. With reference to your letter number quoted above, I'm directed to convey such and such approval, draft award, such and such, for acquisition of land for upgradation of Serkan to Bakar Road by PWD, Mizoram. Payment should be made by cross-check and not in cash. 15% of the land value in respect of land cover by house pass or stall pass or shop pass or periodic pata or land lease shall be submitted to Revenue Department in case on land value as required under such and such. The award in respect to Pu B. Lalzomliana of Bukpui village amounting to 45, the amount is written such and such only, has been omitted for want of clarification as sought earlier. Compensation should be disbursed subject to the conditions stated below. Genuineness and authentication of the passes should be as per register record. Proper marking of the land acquired should be done at the spot. B. Calculated amount of draft award after deducting such and such. And again, Annexure 4, that is in page 30. Type copy is 31, Your Lordship. Clarification of Bilal Zomliana's land compensation. With reference to the above, I have the honor to submit here with clarification in respect of page 31, type copy. In respect of Bilal Zomliana land compensation. 1. That the said claimant Bilal Zomliana is rightful owner of the said periodic pata. There is no encumbrance upon the said land, that the said land is actually acquired and completed the works within the said land by PWD. That all acquired land is purely divided road and not only extension or upgradation. This type of work took vast area of the land, which increased the claim amount. The said claim is verified on the spot and assessment was done and found genuine, and his claim amounting is also found to be correct. This clarification may kindly be considered and approved by the government as verification is thoroughly conducted by Revenue Department, PWD, VC, and claimant concerned. So with regard to they dispute the land area of the petitioner number 1, which was clarified by the concerned authority, and it was awarded 45 lakhs, as I have assumed in page 7, 45 lakhs 56,736, which was clarified. So after assessment as stated by the Landed Council, there is no measurement at all, Your Lordship. In the reassessment.
Yes.
Reassessment, they have written that 6,000, that annexure additional affidavit, annexure number 1, it's written 67788.
So this amount of assessment,
Yes.
which comes to how much? Both total?
Total, it's come to land value plus crops, 20 lakhs, 3,112.
This you have taken.
Yeah, that I've taken on protest with the permission of this Honorable Court. And, Your Lordship, with regard to petitioner number 2 and number 5, even though their past or periodic land value is not given. And here the difference also made. Petitioner number 2, earlier they have paid 3,55,950. In the chart shows that, Your Lordship, the difference also. So, and what we have prayed is that, Your Lordship, in this case, the award is not set aside, the previous award by the WA, and the WPC 167 of the 167 2017 direction is that to verify the faulty process, and those who are affected genuine should be paid within a month, within 2 months. That's all. But they reassess everything. And those, some are more, some are less, and some are bogus claim, they claim that. So we are genuine person, even in the both assessment, we are affected persons.
Okay, in the reassessment, where's the petition number 2?
Petition and reassessment, yes, I have marked. Petitioner number,
Serial number 12.
serial number 2 is Your Lordship, petitioner number 4. And 12 is number 2. And 36 is number 3. 27 is number 5.
36 or 56?
27. 127, page 9. Pase na book po.
Page 9.
Page 9. Last serial.
Pasena, who is he?
Pase na petition number 5.
What about the others?
Yes, I have that P
1, 2, you have shown me. 4 is there.
1.
And 5. Where is number 3?
3 is
What
3
is
is 36, 56.
PC.
PC Thang Huama.
Okay. So what all have they've got? They've got only towards the crops.
Yes.
The value of the
And
crops.
they said that in the second reassessment, with regard to Pasena, Your Lordship, they said that they have paid land value, but it's not here. 187 here, Pasena. In the previous award, we are not given, But in the second assessment, Pasen was given land value, but not given crops. Only land value. And their stand is that, Your Lordship, in their affidavit, affidavit 19 filed in the 19/2/2020, they have stated that here they have admitted with para 6 of their affidavit, which was filed in
Affidavit filed
on 19/2/2020,
yes, what?
para 6. The claim of petitioner number 1 was verified on the spot, and the same was found genuine, as well as his claim amounting such and such was also found to be correct. However, this was before the reassessment.
Affidavit dated 16 December.
19/2/2020.
How many affidavits are there?
They have filed 3 affidavits.
19-2.
Yes, the thickest one, I have marked in 19/2/2020.
Yes, which paragraph?
Paragraph number 6. Here, that with regard to statement made in paragraph such and such, in continuation of clarification awaited in respect of respondent petition number 1, the respondent revived letter such and such had conveyed its clarification, wherein it was stated that the claim of the petitioners number 1 was verified on the spot, and the same was found genuine, as well as his claim amounting to was also found to be correct. However, this was before the reassessment conducted by verifying team consulted by the district collector as per such and such. And
What is the explanation regarding not awarding the value of crops
they have not mentioned
in
that,
respect of the petitioner number 5, is it?
yes, 5, Pasena.
Pasena.
Yes. Pasena, even though they have given land, that nothing is a mentioned statement.
Value of crops is higher than the value of land.
Before
Before it was 1,53,254.
yes,
That has been reduced to,
86,000 only.
so the crops are more valuable than the land itself.
Yes.
Or what?
At that time, yes. It's not. And what their stand is that the learned court passed in the WPC 167 of 2017 directed to reassess the land. But there is no such direction in the order. And here, para 17 of the said affidavit, they have said that the Honorable Court gave direction to the state respondent to make reassessment, but there is no such direction. That's why they have reassessed the same. Ako last year. Ang Manila ko. I love you on the additional. And again, they have filed affidavit on behalf of respondent number 2. In affidavit filed on 16/12/2021, it's only the enclosure which was. And again, they have filed additional affidavit. Additional affidavit 25/8/2021. Here, they admitted that in respect of Trump Dona, periodic Pata land value was not given. They have admitted also. The main stand is that, as directed by this Honorable Court, they have reassessed.
But one thing is there, you have not questioned that, isn't it?
I have questioned in
Why?
here in this case.
No, in this case you have questioned, but
Yeah.
what about that order?
I have enclosed in my petition.
No, order passed by the court in WPC 167.
Yes, I have enclosed here and dispute.
No, you have enclosed, but you have not challenged that order, isn't it?
Yeah, I have not challenged because the direction is genuine. Because it's not directed to reassess. It's directed to find out faulty process, and they've made, but more than the direction of this Honorable Court. That is my stand, Lordship. The direction is very clear.
No, to come to the direction, before
Yes.
that, you have to conjointly read all the paragraphs.
Yes,
Paragraph 4, 5, 6. Then only the conclusion comes at paragraph 8.
yes,
So there was a lot of faults.
yes. But with concern to our land, Your Lordship, there's no such faulty process or anything.
So that liberty was granted by the court to look
Yes.
into the faulty process.
Yes,
And whether there was a faulty process or whether there was not a faulty process,
yes.
how do we determine that?
Because in the next sentence, for identification of the actual affected persons persons and the subsequent disbursement of compensation to the affected person within a period of 2 months from the date of receipt of this order. So it means that those affected, the genuine landowner, should be given within 2 months. It's not saying that they have to reassess, but they believe that this direction is to make reassessment. That is their stand.
Okay, apart from the assessment,
Yes.
what was the, anything recorded about the faulty process?
With regard to the present petitioner, nothing is there.
No, with regard to everybody.
Regard to, because,
See, I'll tell you,
yes,
this 167 was filed
yes,
and disposed of
yes,
with an observation that they say that there's some faulty process, some
yes. The bogus claim,
claims was bogus, some areas, some discrepancies are there. So court said that, okay, you take into account all those things and complete the thing and pay. Now, what did they do? Apart from coming up with the reassessment, was there no separate finding that after verification, we find that this area has to be this much and so, hence we had to assess this, like that? Or straight away they went for assessment?
straight away, they have
Is there no
visited,
document?
yeah, they have stated here, they visited the place and spot verification was made.
So verification report is not there?
They have not enclosed all the,
Ms. Lundui, any verification report?
Your Lordship,
See, 167.
Yes, Your
WPC 167. Court permitted you to go ahead with your action of looking into the faulty process and to finalize the thing.
yes, Your Lordship.
What did you do thereafter? We've seen that you have made an assessment, no doubt, but prior to that assessment, was there a verification done? Was there a report prepared? And accordingly, calculation done or recalculation done?
Your Lordship, as per the affidavit, I can see that there was a meeting which was held, and they have been annexed in Annexure 3 and 4 of the affidavit of opposition filed by the state.
On which date? There are 3 affidavits.
Your Lordship, the first affidavit in opposition.
Yes, which one?
Your Lordship,
Paragraph?
annexure, this is in paragraph
Annexure?
number 9, Your Lordship. Paragraph number 9.
9.
If I may read, Your Lordship.
No, show me the annexure.
That is in page number 1, Your Lordship. Sorry, 21.
21.
Annexure 3. Annexure
This-
3, page 21, Your Lordship. So, Your Lordship, this is where the meeting was held in connection with the WPC 167. And this was, I believe, this is the first meeting which was held, Your Lordship. This is on the 9th of April 2018.
So this is only a process which was initiated.
Yes, Your Lordship. But at the same time, Your Lordship, if I may include in my at this juncture that the WA1 2023 has already superseded the in the observations made in
No, we'll come to that later on.
Yes,
First, you
Lord.
tell me what you have done. Now, first of all, meeting was held on 6/4/2018,
Yes, Your Lordship.
Correct.
And then on the 10th
on Friday.
Yes, Your Lordship. And then on the 10/4
On
2018.
6/4/2018, what was done was that schedule for public hearing will be chalked out by the district collector. Then 3.3 para says, while screening of claims of public hearing will examine as to whether lands of property of so-and-so have actually been affected, as well as area of land in the kinds of numbers of so-and-so. This was the first step.
Yes, Your Lordship.
Then the second step was,
And then, Your Lordship,
and who
Another-
participated here?
another meeting was held, Your Lordship.
When?
Your Lordship, in this, in page number 23, the attendance sheet has been attached.
Yes, who are they?
These are the additional DC and the LNJ department is also present, Your Lordship. And
No,
then
they are the authorities, but what about the claimants, landowners?
the claimants, Your Lordship, they were later made aware of that there'll be a verification via newspapers, Your Lordship.
Now, you come to page 24. This is another meeting
Yes, Your Lordship.
which held
This
on
was in 11th to April 2018.
24, page 24.
Yes, Your Lordship. And then the English translation is on page 25.
This was held on 10 April. Earlier one was 6th April.
Yes, Your Lordship. And in this second meeting, Your Lordship, all the VC, a copy was also given to all the VC Serkhan to Saipai village and also all members concerned for information. And also all the President's branch YMA Serkhan to Saipai village was also given a copy.
Though this also again says that verification shall published in local newspaper.
Make it known
Verification
throughout the
team
state.
1 and 2 shall be constituted comprising of so and so. Then verification shall be published in local. Then thereafter,
And thereafter, Your Lordship, on then annexation number 5, here it was the team was constituted, Your Lordship. There was team 1 and team 2. However, later, Your Lordship, it was decided only one team will proceed.
although 2 teams have been comprised.
Initially, yes, Your Lordship. However, only one team was comprised later, Your Lordship. This was in the minute. This is in the translation page number 28, Your Lordship.
28. What is the date? 18/4.
18:4, yes, Your Lordship. Here, they had just mentioned that there were 12 points were enumerated, Your Lordship, and then after this, Your Lordship, again it was
All these happened in the month of April only.
yes, Your Lordship.
6 April, 10th April,
Yes, Your
then
Lordship. A chronology had been made, Your Lordship.
11 April, then 18 April. Then ultimately, where is the report?
And then ultimately, Your Lordship, the report. This has not been attached in the affidavit, Your Lordship.
All right, you bring the records then,
Yes, Your Lordship.
because we would like to see how you have proceeded.
Lordship, actually, we call us for verification to be present in the spot. We are present, but there is no such measurement at all. They compared our past and see the land without measuring. They said that you are genuine, so it's no need to take any measurement. So they're just doing that. But when it comes to the reassessment, they said that my land is measurement is less than the previous award. They just said that without we are present, no measurement is taken at all in the second verification. Public hearing was there, asking the landowner to be present on their respective land. The petitioner hearing are also accordingly present on the spot at the time of the said verification, and no dispute. Our claim was no dispute. No measurement has taken up. However, when it comes to the reassessment, revised award, it's reduced.
Your Lordship, if I may, the additional affidavit was sorry, Your Lordship. In the additional affidavit, affidavit on behalf of the state respondent number 2, Your Lordship, this was filed in 16 December 2021. So, in page number 8, annexion number 2, Your Lordship, there is a report on Serkhan Baga re-verification. Your Lordship, this is the affidavit filed by the Land Revenue Settlement in 16 December 2021, and there in the annexure 2, page number 8, there is a copy titled Report on Sirkhan Baga Road Re-Verification. Page number 8, Your Lordship. Your Lordship, this date, it will be 18th May 2018.
18 May.
Yes, Your Lordship. This is a month after the spot verifications were conducted. Roughly a month, Your Lordship.
So if you briefly read through this report,
Yes, Your Lordship.
it says that 167 numbers of bogus claims have been weeded out. That's all. It doesn't say that even for those genuine claimants, the area is small, not as what was given earlier. Because this report is very important.
Yes, Your
167 is there, nobody challenged, neither the state nor the respondents or any stakeholders. And the stages of compliance you have shown me in April, different dates were fixed. Publication, newspaper publication, reports. Ultimately, report has come by this annexure 2. And the fact-finding team or the verification team says that 167 numbers of bogus claims are reduced. They have been weeded out.
Yes, Your Lordship.
So 167 numbers will not get the payment.
Yes,
The
Your
remaining
Lordship.
person should get the payment. Where is the question of revising it again?
Your Lordship, the
This
question.
is what they say.
Yes, Lordship. That is the main crux of the bone of contention here, Lordship, because now in the 167/2017, Lordship, in the foregoing paragraphs before the directions, it was admitted by the state that there was an inflation and overlapping of the assessment, which was actually, in legal terms, we would say it is arbitrary, Your Lordship.
No, that was a foregone conclusion.
Yes, Your Lordship.
167, while disposing it off, court took into consideration all your pleadings and all that. So respondents admitted this, that. But ultimately, what had followed thereafter was the actual fact finding and the report come up by this team. Where in the report does it say that this much is excess, this much is the actual amount? So as to appreciate that the amount has to be reduced.
Yes, Your Lordship.
Because ultimately the amount is reduced as the figures shows.
Yes, Your Lordship.
Why
Now-
was it reduced?
Your
And
Lordship,
on what
because-
basis?
Because, Your Lordship, if it is noticed here in the verification report also, Your Lordship, in paragraph number 2, they say that since the initial road alignment is not followed during the actual construction, the verification team highlighted the actual road construction work has been mostly done by widening of the previous truck-able
No,
road.
you are reading from,
Your Lordship, from the re-verification.
where is that? Page?
Your Lordship, the same re-verification report, Your Lordship, the one that I was referring to earlier, the page 8.
Page 8. Which part are you reading?
Your Lordship, the point number 2.
2. Okay, read.
Since the initial road alignment right of way is not followed during the actual construction, the verification team highlighted that the actual road construction work has been mostly done by widening of the previous truckable road, and in some parts diversion was also being done. Also, some parts of the new construction work which follows the initial alignment but were abandoned are also recorded. For giving a clear-cut understanding to the claimants and respective village people, public hearing was conducted by the verification team before starting the verification in each and every village, as well as during the verification process. During the verification process, landowners, village council members, and verification team members, including Sekhan Baga Road Coordination Committee, were present on the field. Land holdings having land value like pata, etc., remeasured with due care and duly recorded crops which are damaged by construction work are also recorded in consultation with landowners and concerned VC. Number of crops that can be accommodated in such areas are estimated, taking into consideration the area that could be occupied by such crop as to work out acceptable and
No,
fairly
see,
correct
Ms.
estimation.
Nundui, see, there's no problem about that. You had the liberty to find out all those things. What I'm asking is that where have you found out that? Where is the calculation or the report saying the area given this earlier was this much, but on verification it was this much. Hence, we had to pay only this much. Because this report ultimately in the last paragraph says 167 are weeded out. It does not say that even those genuine claims are to be reduced to this extent on the basis of the fact finding, which is as follows. Then you deduct and give them as per the fact finding, but that is not there.
Yes, Your Lordship, but
So how do you simply reduce like that?
Your Lordship, it was particularly with the case of the current petitioners, Your Lordship, another additional affidavit was filed on behalf of the state respondents, which was filed in August 2021. So here, Your Lordship, in the last,
I'll come back in 5 minutes, okay?
yes, Your Lordship.
You have to show me that.
I seek Your Lordship's indulgence. My Lord, there's a hearing item in the hearing column, item number 8.
Yes.
Yes. My Lord, we have received instructions to proceed with the hearing to go for disposal on merit.
Okay.
So, my Lord, if this may kindly be taken up next week?
Mr. T.L. Zakima, Learned Counsel, submits that he has been instructed to proceed with the matter by his clients, and therefore submits that the matter may be taken up for hearing in the next week. So Mr. C. Tantia Lima, Learned Counsel, for the
Respondent 1 and 2.
respondent number 1 and 2 has no objection. In view of above, list again on when in the weekly hearing list.
Weekly hearing list, my lord.
In the weekly hearing list commencing from 2nd of February 2026.
I'm deeply obliged.
I seek Your Lordship's indulgence in mentioning item number 2 of part 1, my lord. This is in the admission stage. It was taken up last Monday or Tuesday, my lord? Tuesday. And I was instructed to get certain instructions. My lord, I have not received the full instructions. If it can be adjourned after a week, my lord.
Mr. Falzwala,
I have no objection, my lord. I'm for the respondent number 1.
Mr. Mehdi is for respondent 2.
yes.
Praying for adjournment.
Yes.
My lord, and date may fix, my lord, only date mark.
Okay. Intinya doang.
Mrs. Linda L. Fambol, Learned Counsel, for the petitioners, submits that she needs further time to obtain instructions in terms of the last court's order. In view of above, and has agreed upon that the matter be listed on
6th of February, my lord.
Friday ba? All right, my lord.
6th of February.
My presence may be reflected, my lord.
Mr. S.K. Mehdi, Learned Counsel, Learned CGC appears for the respondent number
2, my lord.
2 through RBC.
Obliged.
My lord.
With the consent of the other party, may I seek Your Lordship's indulgence in mentioning item 7 of hearing list?
So this becomes mention time.
Yes, my lord.
Huh? Yes.
Yes, my lord. My senior has personal difficulty today.
10:30 is the mentioning time. Now you have made 12:20 as a mentioning time also. Can you say yes? Which item?
Item number 7.
Of the hearing list.
Yes, my lord.
When do you want it? When do you want it?
After 2 weeks, my lord.
You
No
are there?
objection, my lord.
Okay. Let's wait for on behalf of Mr. Bilal Omega, Learned Counsel, for the appellant and not objected to by the other side. List the matter for hearing after 2 weeks.
Obliged.
So, tell us.
Yes, Your Lordship. May it please, Your Lordship, in this affidavit on behalf of the respondent number 2, on page number 3, paragraph number 4, Your Lordship, it has been stated that
No. Affidavit in opposition.
by
Dated?
this is
Dated?
16th December 2021.
Okay. At paragraph number?
4, Your Lordship, page number 3.
Yes.
If I may read, Your Lordship, that based on the verification report, the assessment for compensation was made for exact area damaged crops to be acquired for construction of the road. In the original Award 3 2014, Part F, Book B, the area to be acquired was reflected as 151 kilometers, and whereas in the revised Award 3 2014, the area to be acquired was reflected as 241,286.88 square feet. From this, it can be seen that the area after verification as per Guwahati High Court was greatly reduced. The area of land of the instant petitions are also reduced, and since the area is reduced, the number of crops are automatically reduced. Comparison statements on the amount payable to the petitioners in award number 3 and revised award number 3 2014 is enclosed here for ready reference.
See, reduce is one thing, but in respect of petition number 5, it is totally nil.
Yes, Your Lordship.
It has
However,
disintegrated.
that would be, Your Lordship, at the time of
And you say
actual.
that it has been reduced to what? It has been reduced to 0 crops in respect of respondent.
Yes, Your Lordship.
And
However,
instead now you have given him or her value for the land, which is a bit less.
yes, Your Lordship. However, at the time of verification, there was no. They might have accepted the money in under protest. However, Your Lordship, at the time of the verification itself, whether there was actual verification or there was they had just seen the Pirik Patta, or whether the actual area was measured or not, that becomes a factual dispute, Your Lordship. It cannot be entertained in the writ petition, Your Lordship. And also, Your Lordship, their prayer portion only prays for.
We'll do one thing, you produce the records, how you have calculated. I want to see.
Yes, Your Lordship.
Because the report says only 167 numbers have been weeded out. So 167 is called the steno. 167 is found to be bogus. They will not get money for compensation. Take them out. The remaining part should have been given, including the petitioners. But then you said that the area was, like somehow remeasured and all this. How you have remeasured? Let us see. Bring the records, we'll see.
Yes, Your
By the
Lordship.
next day.
Yes, Your Lordship.
How much time should you require for that?
Your Lordship, if at least 2 weeks time may be
2
granted.
weeks time.
Yes, Your Lordship.
Okay.
Because the documents will have to be produced from the DC Kolasip and also from the EE Kolasip. And maybe from the land revenue as well, Your Lordship. So if 2 weeks time may be granted.
And Your Lordship, beside the petitioner number 5, petitioner number 2 also has a periodic pata. There is no only crops, no land area was given.
But again, Your Lordship, that is a fact.
Land value was
No,
given.
land area was not given earlier also, isn't it?
Earlier it's not mentioned in total only.
That's what. So, in respect of that, since the acquisition is under the 1894 Act, there is a process to protest, isn't it? Section 18 was there also. You have not resorted to that.
Not yet.
That's why. Now, can we open that issue again at this stage?
The thing is, in this case, Your Lordship, previously what was there, it was approved, and the government trying to cancel the award 3 of 2014, and they have approached this honorable court. It was allowed it was confirmed award number 3 of 2014. So being aggrieved by that, the government filed appeal. In the appeal, appeal was pending, WPC 167 of 2017 was filed in the single bench. So during the pendency of WA, 167 2017 was disposed of. The direction is there, and they have taken in accordance with, if they taken steps in accordance with the judgment and order, we have no dispute at all, because we are genuine, we are there. They came for, we are informed to present in the verification spot. So we are there, and they came, oh yeah, genuine, no need to verify. And like that only they've come. And so since award 3 of 2014 is not set aside till date, so you think that you can claim in accordance with the award number 3 of 2014?
No, at best you can stick to the first award.
Yes, first award.
You can go
that
beyond.
is-
You can't go beyond that now,
Yes,
saying that it should be enhanced to some
Yeah,
amount.
yes. That is
If
different
you
thing.
succeed, you'll
Yeah,
get the first award.
Yes,
That only.
yes.
Because otherwise the law is clear. If you have any
And you
grievance.
have to know that Your Lordship, award is made in 2015, and belatedly after 167 of 2017 was passed, the road is already there, and the I doubt that if they made measurement also, it cannot possible. And it cannot be possible to verify crops also.
Your Lordship, if I may submit, Your Lordship, this petition being regarding question of law, Your Lordship, when the award was accepted under protest also, Your Lordship, it only preserves the right to legal processes, and also, Your Lordship, but it does not preserve the right to dispute factual measurements as well, which was conducted in their presence.
I'm not disputing right now, Your Lordship. What I'm saying is, if the state authority followed and complies with the 167 of 2017 order,
And
they
Your Lo-
have to find out bogus claim and all that. But those who are genuine persons should be given within 2 months,
and Your
in
Lordship,
accordance with the award number 3 of 2014.
Your Lordship, if I may be allowed to make a new submission,
Okay.
which is that
See, we're not disposing the matter at
Yes,
this stage.
yes.
Even if you submit what is there now, I want to see that records, that's all. You
Yes, Your
produce the
Lordship.
records and
And Your Lordship, at this stage, I would also submit to the court that the payment had been accepted. And would that, and then after 5 years, you repudiating the transaction, would that not also attract estoppel as well, Your Lordship? That is also one question of law.
Your Lordship, in that regard, we have permission by this court to receive on protest. So the permission you have.
And then that also again, Your Lordship, we are going in circles again.
They have not challenged that on protest received by this order.
At the same
Till
time, Your
date.
Lordship, there is no challenge as to the revised award as well in the petition.
please
Nor-
write. Okay. Please write, the matter relates to upgradation of Ser Khan to Baga Road. Stop after following the 11 provisions of the Land Acquisition Act 1894, comma, draft award number 3 of 2014, bracket, part F dash book Pui, close bracket, was prepared by the district collector. Policy on 23/4/2015. Wherein the names of the petitioners appear at serial number 14 and 14 bracket small a in respect of petitioner number 1 and serial numbers 13, 61, 3, and 87 in respect of the remaining petitioners respectively. Stop, although the award was approved by the government, but now who has filed this 167?
It's some society.
It was filed by the NGO
I want to know, I want
Coordinate
the
committee.
names. What is the name?
coordinate committee, Your Lordship.
Where do we get that?
Your Lordship, this is from the WA1 2023. That was
Paragraph number? What is the name and style of the name of the
Your
petitioners?
Lordship, this coordinate committee is mentioned in WA1 2023, paragraph number 5, that is page number 4. In the second line, Your Lordship. Page number 4, paragraph number 5. second line.
What was the last line? Oh, a certain public interest group under the name and style of Coordination Committee, Serkantu Baga Road, represented by its chairman, filed WPC number 167 of 2017 before this court, alleging that there were a number of fake claims made by the landowners, and at the same time, the genuine landowners who were actually affected were not getting their dues, were not getting their due compensation. Stop. Therefore, the committee that was formed approached this court for suitable direction to check the irregularities. Next para. The writ petition was disposed of by order dated 19/3/2018. By directing the respondents to take into consideration the faulty process which inadvertently cropped up in the final compensation list and complete the process both for identification of the actual affected persons and the subsequent dispersal of the compensation to the affected persons within a period of 2 months from the date of receipt of the copy of the order. Along with the writ petition with annexures. Next para. Pursuant to the above direction, the respondent authorities carried out the re-verification and came up with a revised award. Where's the revised award? Page? The revised awarded page?
This is, Your Lordship, the revised award is on page number 24, annexure 4. That is from the,
Where?
this is, Your Lordship,
Is it page 36, Mr. Dinari?
Yeah,
Reassessment.
But it's not complete.
Award is the same, but it's a reassessment.
Only revise the reassess.
Name and
Award
number.
name, award name is same.
Name and number of the award is same.
Same, revise,
It's only reassessment.
reassessment.
Is it annexure 6, page 36 of the writ petition?
Yes, but here it's not detailed, but they have enclosed by the respondent.
Where?
this is on, Your Lordship, this is on our, the same affidavit that I was referring to, which was filed in 16 December 2021. There on page number 24, Your Lordship, that is annexure 4.
Here, the name is not seen, but if you see from the additional affidavit filed by them,
Page 10, is it?
Your Lordship, 24, annexure 4 of the affidavit filed in December 2020.
What did I say last? Came up with?
but the name is not shown here in draw. Lingpo lang lang.
dated 11/7/2018, by which the amount of compensation payable to the instant petitioners have been substantially reduced. Stop. Aggrieved, the instant writ petition has been filed. Stop. Mrs. Dinari Tiazu, learned counsel for the petitioners, submits that all that was directed by this court in WPC number 167 of 2017 was to correct the faulty process which inadvertently had cropped up, and not to make a reassessment of the amount of compensation payable to the genuine landowners. Stop. She therefore submits that the amount that was assessed earlier should be disbursed to the petitioners, less the amount which has already been paid to them in the meantime, under protest. Stop. The next para, the state respondents have filed 3 affidavits in opposition. That is affidavit in opposition dated 19/2/2020. And what is the second one?
Your Lordship, the second one was filed.
Dated? Second one is dated?
Your Lordship, in August, I'll just. This was filed in on the 25th August 2021, Your Lordship.
Comma 25/8/2021 and 16/12/2021. Stop. In the affidavit dated 16/12/2021, the state respondents have annexed the report on Serkan Baga Road re-verification as annexure 2 at page number 8. Stop. The report concludes as follows. Dash. Next line, open inverted comma. The fact-finding team, oblique, the verification team, therefore, carried out the re-verification process by following a systematic and fairly reasonable process, and the report is considered to be neutral, comma, impartial, comma, practical, and unbiased. Stop. It weeds out as much as 167 numbers of bogus claims and reducing the compensation amount by rupees 682,03305.00. Open bracket. Rupees 6 crore 82 lakh 3,305, close bracket only. And the proposed final amount for disbursement to the actual affected person is rupees 568,34327.00. Open bracket, rupees 5 crore 68 lakh 34,327, close bracket only, full stop, close inverted comma. You'll find this in the red flag, okay? This red flag if you want to check it up. A to A. Stop. Apart from this, there is no material to show as to the manner in which such verification and computation has been done. Stop. The same would be relevant in view of the fact that the amount has been substantially reduced, and that in respect of the petition number 5, the amount that was given to, who's number 5, lady or gents? Given to petition number 5.
5 is, yes, person.
He or she?
He.
Given to him. Please read the line. What is that last line? Towards crops damage is no longer available in the reassessment, and instead he has been given some amount towards land compensation. Stop. Further, while some of the petitioners or persons have been given compensation towards land for having possessed periodic patta, but then again, some of the landowners, including some of the petitioners having periodic patta, have not been given any compensation for their land. For their land, you cancel that. Towards land value. Next para. The above being the position, the Ms. Lal Nuntului, learned government advocate, appearing for the state respondents, shall produce the complete records pertaining to the Sherkhan Bagha Road re-verification corresponding to the report dated 18/5/2018. Stop. In other words, the records pertaining to the process undertaken by the respondent authorities pursuant to the disposal of WPC number 167 of 2017 by order dated 19/3/2018 by the next date. No, 2018, full stop. By the next date, cancel. The said records should be made available by the next court date. List 2 weeks.
Your Lordship, if 3 weeks time may be granted, because I'm not sure if I'll be able to attain all the required documents in such a short span of time.
No, you don't take 3 weeks at a stretch. If there's some difficulty, we'll give you further time.
Yes, Your Lordship.
Scholarship is just nearby and you never know. Get it. List the matter again.
Your Lordship, on the 16th,
February.
yes, Your Lordship.
I'll give you 19th February.
Much obliged, Your Lordship.
Stop. A copy of this order be furnished to the learned government advocate for doing the needful.
Item 3.
You should ask them.
Your Lordship, this writ petition is about the illegal suspension of Kamalanagar for Village Council, and we are challenging the impugned order notification dated 15/9/2025, and the Village Council was suspended for 3 months only, and it has already expired on 15/12/2025. And by this Honorable Court's order dated 12/12, due to that order, no further extension of the Village Council suspension has been made. So this writ petition has become infructuous. So with the leave of this Honorable Court, we may withdraw this writ petition.
What is the term of the village council?
Term of the Village Council is for, my Lord,
It started from Kamalanagar 4.
Kamalanagar for, yes, my Lord.
Okay. The term is for 3 years or 5 years? 4 years. Oh. VC.
I'm so sorry, I'm not very sure of that. I believe
Then
it
how
is
do you
5
say it's
years.
infructuous?
Uh,
There has to be a basis. You see, we'll calculate the date. If it's 3 years, we'll say from this date to this date, term is already over.
No, my Lord, it is for suspension for 3 months only.
Oh, it's regarding suspension.
Yeah, it is a suspension for 3 months only, and the suspension has already expired on 15/12/2025.
Then now what is the position?
Now it
You're
is
back in
functioning.
power.
It is stayed by this Honorable Court. The suspension order is stayed. Via the order dated 12/12/2025.
Legality of the order dated 15/9/25. What is 15/9/2025?
It is the impugned notification which we are challenging. Page 83. The retyped copy is at page 84.
84.
Yes, my Lord.
Is pleased to put the Kamalanagar so-and-so under suspension for 3 months. Correct?
Yes, my Lord.
So 3 months from 15 September.
Yes, my Lord. So it has expired on 15/12/2025.
15/12 December. Then court has also stayed.
Yes, my Lord. Via the order dated 12/12/2025.
Okay. Now the very stay order passed, the order itself has already expired.
Yes, my Lord.
So now what is the position?
It is functioning.
It's functioning now.
Yes, my Lord. They requested to withdraw this writ petition because it has become infructuous.
Okay. You're for the petition, right?
Yes, my lord.
What's your good name?
Laltan Louis.
Please write Ms. Laltan Louis, learned counsel for the petitioner. Petitioners submits that this writ petition was filed challenging the order dated 15/9/2025, bracket annexure 8. Not order, you write notification. Notification dated 15/9/2025, bracket annexure 8, by which the Kamala Nagar Roman 4 Village Council was placed under suspension for a period of 3 months by the local administration officer, Chakma Autonomous District Council, Kamala Nagar. Stop. When the matter was taken up for motion on 12/12/2025, this court passed an interim order staying the impugned notification. Stop. Since the suspension was only for a period of 3 months, the same has expired during the pendency of the writ petition on 15/12/2025.
Yes, my lord.
And therefore, cancel that. Stop. She submits that now the petitioners have been allowed to function
Yes, my lord.
as the village council of Kamala Nagar 4. And she has instructions to withdraw
Yes, my lord.
the writ petition. Stop. Next para, Ms. Laltan Louis, learned government advocate. Affairs for the respondent.
Number
Numbers.
2, Your Lordship.
Numbers,
2, Your Lordship.
only 2.
Yes, Your Lordship.
Okay, number 2. And she also agrees to the submission and submits that she has no objection to the prayer made by the petitioners. Next para, in view of above, the writ petition stands disposed of as withdrawn. Stop. Interim order passed earlier stands vacated.
Much obliged, Lordship.
Not vacated, you write stands merged with this order. Okay? Mm. Okay.